depending on where you are. Excellencies, colleagues, ladies and gentlemen, it's a pleasure and a privilege to welcome all of you to this event about the fight against impunity and the role of UN-created accountability mechanisms organized by the International Commission of Jurists and the Kingdom of the Netherlands. We're very grateful that you're all here to take part in the debate. I would especially like to extend a warm welcome to our keynote speakers, the ICC Chief Prosecutor, Ms. Fatou Bensouda, and the Assistant Secretary General for Human Rights, Ms. Ilse Brandt-Keris. And I'm very happy that the Minister of Foreign Affairs of the Netherlands, Stef Blok, is with us to deliver the opening speech. And I would like to ask you to mute if you don't speak, because there's some noise in between. This event builds upon a smaller conference on the same topic organized in November last year. Today's event is aimed at gathering further ideas and insights about strengthening the fight against impunity. Accountability is one of the key priorities in Dutch foreign and human rights policy. Both the ICC and OHCHR are key players in the fight against impunity worldwide. The Netherlands is a strong supporter and proud host state of the ICC. The international community needs to stand firmly behind the court, crucial for the prosecution of international crimes when states are unable or unwilling to do so. OHCHR has become more and more important in the documentation of human rights violations and the collection and preservation of evidence. And of course, the fight against impunity relies on the tireless efforts of NGOs, individual activists, evidence-gathering mechanisms, and perhaps most importantly, victims and survivors. In Geneva, the permanent mission of the Kingdom of the Netherlands has continuously emphasized the importance of accountability and the fight against impunity. In order for us to take steps and provide justice for victims, we need to make sure that we join forces and complement each other. I therefore stress again that we value your participation here today, and I encourage you to share your sharp remarks, innovative ideas, and tough questions during the Q&A. And I now give the virtual floor to Sam Zarifi, Secretary General of the ICJ, to guide us through the discussions today. Sam, the screen's yours.
Thank you very much, Ambassador Van Dalen, for your ongoing support for the ICJ and for the quest for accountability. Excellencies, colleagues, friends, thank you for joining us. It's a momentous day for a variety of reasons, and I'm glad that we could have your attention with us today. I want to start by echoing our gratitude to our speakers and panelists today, and in particular, Foreign Minister Stef Blok of the Kingdom of the Netherlands, Assistant Secretary General for Human Rights, Ms. Ilse Brandt-Keris, and Chief Prosecutor Fatou Bensouda. We're very pleased to have all of you join us today in this important discussion about justice and accountability at what seems like a particularly dark time in world history. For the International Commission of Jurists, when we began working nearly 70 years ago, the notion of global accountability and justice for violations of human rights was our core mandate. And I think at that time, the idea of global justice mechanisms really felt and seemed like an unlikely dream to achieve. And I'm very pleased that now, with the struggle and hard work of many states, activists, international organizations, and more than any, the demands of victims for their right to justice, truth, reparation, and non-recurrence, we've made a lot of progress. And especially in the last 30 years or so, with the creation of international tribunals, the signing of the Rome Statute of the International Criminal Court, the proliferation of universal jurisdiction in many states, we have seen real advances in the struggle for global justice. I think it's important to keep that progress in mind. This trend has accelerated recently, especially really, I would say, in the last few years, as we've seen increasing efforts to create mechanisms that are not only monitoring and documenting human rights violations, but are going beyond that to include the identification of perpetrators and the collection of evidence for possible criminal proceedings, steps towards global accountability. These mechanisms, of course, were created largely in situations where the initial framework for global justice did not seem to work, and there were obstacles. Chief among them, the failure of political will or capacity among some states to observe their obligation to provide justice and accountability for gross human rights violations. And at the top of the global system of governance, post-war system of governance, the failure of the UN Security Council, where especially 3 of the 5 permanent members still have not ratified the Rome Statute, and in many cases have actively been hostile to the International Criminal Court and to efforts for international accountability. So despite the advances, impunity does seem still to be the order of the day, and victims of atrocities around the world continue to be frustrated by this apparent entrenched impunity despite the steps forward. Nevertheless, we do hear victims around the world continue to demand global justice. So for the ICJ, in light of our mandate as global advocates for justice and human rights, we've had to look at this seeming paradox. And we have to ask, how can we improve the operation of the various mechanisms that we have set up since the last 70 years to help the victims reach their rights appropriately? This conference is part of that effort. In our collaboration with the global community of jurists, of human rights activists, we've had support from many states. And in this case, with the Kingdom of the Netherlands, as you heard, we were able to hold a previous conference, a closed conference in November, where we collaborated with different stakeholders, victims, state representatives, the staff of the ICC, the staff of the High Commissioner for Human Rights, heads and staff of various accountability mechanisms, civil society, and different experts. And these discussions have already identified one clear answer, that at the center of all such efforts must be the ultimate goal of honoring the rights of the victims of gross human rights violations to receive truth, justice, reparations, and guarantees of non-recurrence. And to do so, there must be closer interaction and collaboration between victims, between international organizations and civil society groups that are dedicated to documenting these violations, the investigators and lawyers seeking to redress through the courts at national, regional, and international levels, and the various mechanisms that are now bringing these organizations together. Today, we will hear more about these findings as well as other important points. With these 2 events, the Netherlands and the ICJ aim to push ahead for the global struggle for justice. With your help, we hope and believe that these conversations and ensuring closer collaboration and cooperation will realize the dream of the post-war world for protection and promotion of human rights and for punishment of perpetrators of gross human rights violations. So, Your Excellencies, friends and colleagues, I look forward to hearing and learning more from all of you and from our speakers. And I hope and I believe that this conversation today will be just one more step forward in our unending struggle to achieve this important right. With that, I would like to begin and turn the floor over to our first speaker, Foreign Minister of the Kingdom of the Netherlands, Minister Blok. Thank you very much.
Thank you. And first of all, I would like to say that I am proud to host today's event together with the International Commission of Jurists. And of course, I would also like to thank both Ms. Brown-Skeris, UN Assistant Secretary General for Human Rights, and Ms. Bensouda, the ICC prosecutor, for making time to share their experience and insights about strengthening the fight against impunity. Ladies and gentlemen, perhaps you heard about a young man called Omar al-Shagr, who can be seen in the picture on your computer screen and who's also with us here today. Omar is a 25-year-old human rights activist and public speaker who survived torture in a Syrian prison. He's now studying business and international relations in the United States at Georgetown University in Washington, D.C. But that's not the reason that I mention him. I mention him because of the horrors he has witnessed. When Omar was 17 years old, security forces in Syria arrested him for participating in peaceful demonstrations. He was thrown into a dark, filthy cell with many other prisoners. People who were doctors, engineers, teachers, psychologists, economists, lawyers. They had so little space, they could barely move. The only way to cope was kneel and rest your head on your arms to sleep, and to stand up in shifts so other prisoners could bend their knees and sleep as well. Omar and his fellow prisoners often didn't even dare to whisper to one another, because anyone who spoke would be beaten by the guards. But that wasn't even the worst part. The worst part was the dead bodies in the prison and the fact that Omar was forced to tag them all by writing numbers on their forehead before removing them from their cells. And he also remembers the torture, the electric shocks, the brutal daily beatings, the time his fingernails were pulled out, the days he was suspended by his wrists from the ceiling for hours. And of course, the times would put him in the corridor, just so he could hear the torture of others. Then he heard people screaming and begging, saying, "Please kill me. I will tell you whatever you want. Just please stop." In June 2015, Omar was released after 3 years in prison because his mother, who had escaped to Turkey, was able to scrape together enough money to get him out. She paid a bribe of $20,000 to a corrupt Syrian police officer. When Omar got out, he was 20 years old, and he was a shadow of the young man he had once been. He weighed only 34 kilos. He was barefoot, was coughing up blood. It turned out he had tuberculosis. In order to get treatment, he first had to cross the border to Turkey. So he joined a wave of refugees heading for Europe. And the journey began with a rubber boat, a journey that finally took him to Sweden, where he ended up living with a foster mother and his 2 surviving brothers. And since that time, Omar has been seeking justice, not only for himself and for his brothers and cousins who died in prison, but also for the inmates he got to know and who all died. And many of them had asked him not to forget them if he was one day able to escape. "Please, Omar," they would tell him, "if you get out of prison, do something. Talk about this so that people will know." And that's why today Omar is a visible and vocal witness to the atrocities committed in Syria's prisons. He has spoken on college campuses, and he has given a TEDx talk. He has even spoken at the White House and briefed members of Congress. And last but not least, Omar has joined other witnesses, victims, activists, and lawyers, to wage a legal battle for justice in the European courts. And as long as I'm alive, Omar now says, I will work to ensure that the people who did this stand in front of a judge and admit that they tortured me. And it's precisely because of brave individuals like Omar and because of all those other survivors who fled Syria and who are also sharing their harrowing testimonies that we, as governments, as NGOs, as European war crime investigators, and as investigators working for international independent organizations, can now collect evidence of the nature and magnitude of the atrocities committed in Syria. And while there are, of course, still many more questions than answers, survivors are actually seeing glimmers of hope for the first time in years, because courts in Germany, France, and Sweden are now investigating several Syrian individuals. And a country like the Netherlands has decided to hold Syria to account, so that Syrian President Bashar al-Assad and the members of his regime, a regime that is determined to cling to power, will not get away with the horrific crimes they have committed, but will be held to account. It's also why the Netherlands will continue to fully support and cooperate with the International Criminal Court, why we continue to support the many NGOs that work tirelessly to make sure the world knows what's happening, why we run, together with others, UN-mandated fact-finding missions, which are a key step in learning the facts and laying the groundwork for accountability. And why we continue to ensure that mechanisms such as the International Impartial and Independent Mechanism for Syria, but also the Independent Investigative Mechanism for Myanmar, are sufficiently funded and supported, so they can indeed fulfill their mandate effectively. For instance, the Netherlands now again contributing €2 million to investigative teams mandated by the UN, because we know that the road to justice begins with knowing the truth. And I hope that today we can also collect more ideas and best practices on how to achieve accountability as effective as possible. How can different parties cooperate better, for instance? How can specialists do their jobs to better collect, consolidate, preserve, and analyze evidence? And how will victims be, or continue to be, at the center of all our efforts? I believe that only together we can find creative solutions and strive to make new steps towards justice. Not only so families can heal and recover, and not only to make sure people can return to their homeland one day, where there is no more terror, at least not without repercussions, but also so we can send a strong message to all those other perpetrators, people in Syria and elsewhere, who still think they can get away with these crimes. And that message is, you will not get away with this. You will not get away with committing mass atrocities. We will bring you to justice. And by doing so, we will lay the groundwork for lasting peace. Peace is an enduring value, can be achieved only when it is based on justice. And all other options are doomed to fail. So I ask all of you, let's get to work. Let's show all the victims and survivors, like Omar, and like those people in Myanmar, in Yemen, in Libya, in Venezuela, around the world, not only that we care, but above all, that we want justice for our fellow human beings. Thank you.
Thank you very much for your reminder, Mr. Block, of the humanity, of the individuality of every story that we hear about violations and atrocities around the world, and for your very important call and reminder to all of us that that's what ultimately we are all fighting for. And I'm pleased that we will be able to hear, I hope, more from Omar today in the course of the conversation. I'd now like to ask for the United Nations Assistant Secretary General for Human Rights, Ms. Ilse Brands-Karas, to take the floor and to join us. Over to you.
Thank you very much. Excellencies, ladies and gentlemen, I'm grateful to the government of the Netherlands and the International Commission of Jurists for convening this important and timely discussion on the issue of accountability. It's my privilege to deliver this statement on behalf of and at the request of the High Commissioner for Human Rights, Ms. Michelle Bachelet. The High Commissioner had been particularly looking forward to today's event and to joining this eminent panel, but for circumstances beyond her control, is unfortunately unable to join us today. It's a pleasure to share this opening panel with Minister Bloch and Fatou Bensouda, prosecutor of the International Criminal Court. They have both deployed enormous effort in this area of such concern to the international community. As we embark on the work of rebuilding our societies from the upheaval and destruction created by COVID-19, we need to address the racial, economic, and social injustice that the pandemic has laid bare and expanded. We need to tackle the enormous accountability gaps that preceded the pandemic, accelerating its impact. Living with the dignity and safety that stems from the sense that the rule of law is guaranteed should not be a privilege reserved for a tiny few, defined by geography, by race, by wealth, by gender, ethnicity, or any other characteristic. It should be a reality for all, everywhere in the world, and for all in each state. Combating impunity for the most egregious human rights violations is a centerpiece in this endeavor. Accountability contributes to a broader sense of justice, both within and outside affected societies. It also prevents the recurrence of violations through the deterrence of future crimes and by helping to address the root causes of conflict and repression. The principles of the rule of law and accountability are the foundations for all effective promotion and even protection of human rights. Only through accountability can human rights violations and abuses be redressed. Only through the rule of law, coupled with human rights-driven legislation and policy making, can human rights violations and abuses be effectively prevented. Applying a preventive lens is crucial to situating accountability in the overall objectives enshrined in the United Nations Charter. To fully realize the preventive potential of accountability, victims and affected communities require justice to be rendered, their present and future needs to be addressed, and their harms and grievances to be acknowledged and redressed. We have learned that addressing needs and grievances is crucial and often a precondition for victims to participate in the pursuit of justice and truth-seeking. It's essential to enabling them to contribute to preventive work, not merely as victims or survivors, but as equal and recognized actors. Accountability restores victims' dignity and acknowledges their rights. To further broaden accountability as a key tool towards prevention, victims and affected communities must be enabled to take their rightful position in society, one from which they will be able to hold to account those in power in the future. Only then can accountability, retrospective and prospective, truly break cycles of impunity and abuse. This requires a more comprehensive effort from all of us to advocate for, to design and support complementary local, national, and international accountability processes that resonate with concerned populations and contribute to their sense of justice and dignity. To be effective, accountability mechanisms, including international accountability mechanisms, must empower the communities they seek to serve, provide perspective, and contribute to solutions. Outbreaks of violence, conflict, and mass atrocity are often rooted in and accelerated by discrimination, economic inequality, social exclusion, marginalization, and failures to uphold socioeconomic rights. All these factors are exacerbated by the absence or inaccessibility of remedies. Several truth commissions created to deal with legacies of massive human rights violations have found that victims of civil and political rights violations frequently belong to marginalized populations that suffered from socioeconomic inequalities long before the outbreak of violence. These underlying violations of economic, social, and cultural rights are often identified as root causes of the conflict. In other words, accountability is a broader instrument that is vital in identifying and exposing underlying structural and systemic drivers of serious human rights abuses, together with the impunity that we so often see attached to them. Accountability helps to dismantle the web of structures and networks that enabled the violations in the first place. These underlying drivers of cycles of impunity are frequently produced by entrenched and insidious discriminatory practices, as well as wider violations of economic, social, and cultural rights. Put simply, impunity is rooted in persistent political and economic power structures, and these are the products of conscious, deliberate choices. Tackling these issues requires not only courage and the determination to engage for the long haul, it also requires political, financial, and other support from the international community. Determining a suitable long-term action plan must begin with deep understanding of the dynamics of impunity in each specific context. We're easily tempted to place short-lived attention on some initially perceived promising cases and then shift focus as challenges become visible or obstacles arise. But we have learned from experience that it is essential to secure and to lock in hard-won achievements in the process of state reform, rather than simply turning to another, seemingly easier or more promising field. Such long-term vision and determination signals consistency in action and displays the attachment to values and principles that are the foundation of the United Nations. A month ago, on 16th of December, we celebrated the 15th anniversary of the basic principles and guidelines on the right to a remedy and reparation. Speaking from the High Commissioner's own experience as a young woman in Chile, working with victims of the dictatorship, we see this reparative and empowering aspect as crucial, particularly in children and youth. It also helps us construct robust links between criminal justice, reparation, truth-seeking, and steps to prevent recurrence. This needs to take place at various levels, in institutions, across society, and among communities and individuals. Only then do we stand a chance to truly transform societies. Excellencies, investigative bodies are usually created after a human rights emergency has occurred or a conflict has broken out. They are not principally seen as preventive in nature, but these mechanisms contribute to the non-reoccurrence of violations through their collection and analysis of information on human rights violations and abuses, the identification of root causes and accelerators of serious human rights violations, including in the economy and society, identification of alleged perpetrators, and recommendations on accountability and transitional justice. Their work with the media and in other public spaces also strengthens prevention, as does the perpetrators' awareness of the consequences of their acts, which investigative bodies cast in sharper relief. In conclusion, it is our joint responsibility to pay equal, serious attention to every situation where there is an accountability gap and where impunity prevails. Selective application has no place in the rule of law, nor in how the international community should address such crises. The new generation of accountability mechanisms and other initiatives that have been evolving over the past half-decade have been largely determined by particular political considerations. Maintaining the attention of the international community in a certain moment in time and securing its commitment of necessary financial resources for a specifically defined mandate have been among these factors. These efforts are extremely important. They have been warranted in every case, but they represent a floor rather than the ceiling of what must be our ambition in this area. In all situations where victims and societies have suffered violations of such magnitude, they must be able to expect the support of the international community. As the pandemic so painfully reminds us, the suffering of each is the suffering of all. We cannot leave it to a particular confluence of circumstances to bring victims, affected communities, and entire societies redress and protection through accountability. It is our joint responsibility and an expression of our shared commitment to the rule of law to advocate for and insist on systematic, consistent protection of victims of the worst crimes, whoever they are and wherever they may be. I look forward to working with all of you in this direction. Thank you.
Thank you very much, Assistant Secretary General Pires, for highlighting the very important role of accountability mechanisms, not just in responding to violations that have already occurred, but to preventing future violations. And of course, crucial to that in the experience of the ICJ is the notion that there must be a certainty of accountability, and that we have to try to depoliticize the system through which accountability mechanisms are put into motion and respond, so that the victims whose rights we are trying to protect don't have to be further victimized by geopolitics, but rather by the gravity of the situation that they face directly. The role of the Office of the High Commissioner, of course, has been, and the UN human rights mechanisms altogether, has been a major factor in developing the hope that we can achieve this, and something that really I feel is a major step forward in terms of human civilization over the last 10,000 years or so, where we have been. And I think another major step in that direction for all of us was the creation of the International Criminal Court and the notion that there will be a global tribunal to respond to gross human rights violations. And with that, I would like to invite Ms. Fatou Bensouda, the Chief Prosecutor of the International Criminal Court, to take the floor. And Ms. Bensouda, over to you.
Thank you. Thank you very much. Your Excellencies, ladies and gentlemen, I am grateful to the Kingdom of the Netherlands and International Commission of Jurists for convening this important and timely conference. I welcome the opportunity to share the discussions and insights from the successful event of last November with a wider audience, and thank all international bodies, state representatives, and civil society organizations for their virtual presence. I am delighted to be here, and I salute my esteemed fellow speakers, His Excellency Mr. Stef Blok, Foreign Minister of the Netherlands, and Ms. Ilse Brands-Kerris, the Assistant Secretary General for Human Rights. Your vocal support for international justice, the rule of law, and accountability are critically important in today's world, as it lays witness to the continued commission of serious crimes of concern to the international community. I also listened attentively to Minister Blok's remarks at the recent edition of the Assembly of States Parties this past December, when he so eloquently and firmly stood in the defense of the International Criminal Court and its crucial work around the globe where it has jurisdiction. And I seize this unique occasion to express my appreciation for that stance. The ICC, since the start of its operations in 2003, has played its role and contributed to fostering a culture of accountability for atrocity crimes through its preliminary examinations, investigations, court proceedings, and policy work. Notwithstanding internal and external challenges, the court is continuously expanding its activities and advancing its significant mandate while learning valuable lessons and continuously improving its working methods and processes to render its operation as efficient and effective as possible. Of course, the ICC is not alone in the endeavor to address international crimes. Today, in addition to domestic jurisdiction, international tribunals and hybrid jurisdictions, there is an ever-increasing number of UN-created bodies, such as commissions of inquiries, fact-finding missions, and the latest wave of investigative mechanisms. While such bodies are initially focused on monitoring and reporting serious human rights violations, they now have ever more complex mandates focusing not only on reporting, but also on identifying those responsible and, in general, laying the groundwork for potential future criminal accountability. I would submit that due to this evolving trend, the international criminal justice system as a whole is becoming increasingly robust. This development reflects the growing sentiment that whenever atrocity crimes or gross human rights violations occur, they must be investigated and perpetrators brought to justice. While the ICC is the only permanent international body with the mandate to pursue accountability for atrocity crimes, the ICC cannot achieve this goal alone. The court is an important pillar of a global international criminal justice system within which it works in synergy together with the states parties to the Rome Statute, as well as other partners to address atrocity crimes. The UN, given its own mandate and as a staunch supporter of the court, is a natural ally. The ICC and the UN, including all its specialized agencies, offices, and peacekeeping missions, have long-standing ties broadly captured under the ICC-UN Relationship Agreement, in addition to other agreements and memoranda of understanding. Indeed, we are bound together by our shared goal of working towards a more just world and the recognition that atrocity crimes are a threat to international peace and security, a notion captured in the preamble of the Rome Statute. My office sees its partnership with the UN as vital and has long cooperated with various accountability-oriented bodies, always in full respect for our respective independent but complementary mandates. Over the past years alone, my office has been in contact with numerous reporting bodies established by the UN, including commissions of inquiry and fact-finding missions concerning situations under preliminary examinations or investigation by my office, such as the DRC, Darfur, Libya, Central African Republic, Guinea, and more recently, Burundi, as well as Bangladesh, Myanmar. UN accountability bodies can and have been a valuable source of information on allegations on the possible commission of crimes within the jurisdiction of the court. They are particularly beneficial for my office during the conduct of our preliminary examinations work, where the office relies on open source information in order to determine whether there is a reasonable basis to investigate, but also during its investigations. Whilst each commission of inquiry, fact-finding mission, or investigative mechanism is unique, with a different focus and scope of activity, there will normally be several aspects which are of particular interest for the work of my office, and these include the early preservation and collection of evidence. This aspect is in particular important where my office cannot intervene and operate as soon as events happen, or where my office is unable to operate in a specific state or location. In these instances, data and evidence collected by other organizations during what is often called the golden hour after the commission of crimes can prove crucial to ensuring successful prosecutions down the line. Access to information on possible crimes within the jurisdiction of the court. Once such information has been collected by the UN body and the conditions for such access, and also information on the existence and quality of national proceedings in relation to such crimes to determine the admissibility of situations and cases. Some challenges also merit to be highlighted here. where both the ICC as well as the UN mechanism are seized of a situation at the same time. Close and frank interactions between my office and the respective UN mechanisms are crucial, and certain activities may need to be carefully coordinated. Otherwise, there is a certain risk of duplication and overlap, as well as possible confusion and misunderstanding regarding the two mandates in the affected communities. For instance, what is the difference between the OTP ICC and let us say the Myanmar mechanism? Who is doing what? To which office should the witness tell his or her story? And does reporting to one body mean that the other one automatically receives the information as well? Such are questions that needs to be addressed early on, possibly even through joint outreach campaigns where appropriate. Another aspect that merits mentioning here is the difference between a criminal investigation and a human rights investigation. That is to say, the question of standards, including evidentiary standards. Investigations to a criminal standard are of an entirely different nature, and my office has therefore not always been able to rely on information obtained by a UN human rights monitoring body due to the issues such as lack of chain of custody or witness statements being obtained with methods unsuitable for criminal prosecutions. And in this regard, we certainly welcome the new generation of UN accountability bodies, which seem to be addressing some of these issues, and my office has also engaged in collaborative efforts to harmonize practices. But despite some of these challenges, my office's assessment of its cooperation with UN accountability mechanism remains very positive. We believe that increased collaboration and shared practices between the court and the UN accountability mechanisms is vital and may even lead under certain circumstances to a sharing of investigative load. As my office's activities and a new generation of increasing empowered accountability mechanisms are created by the UN, we continue to look to such bodies for potential cooperation or engagement in matters of mutual interest. Your Excellencies, dear colleagues, ladies and gentlemen, besides enhancing cooperation in our operations, we must together also stand firm in the face of political attacks on the rule of law and the institutions that represents our common resolve to address and prevent atrocity crimes and other serious violations of international law. You are, of course, aware of the US executive order against the court, as well as the sanctions and travel bans imposed on myself and staff of my office. It is my sincere hope that the US reverses its policy of antagonism towards the court and the multilateral rule-based order in general, including a withdrawal of the executive order and the measures taken against the ICC. No one wins from such misguided policies. The ICC and I personally have indeed been on the receiving end of potent revisionist forces willing to weaken, even dissolve, in their own words, an independent judicial institution that has the backing of 123 states parties for doing precisely what it was mandated to do. The court and its supporters must continue to stand firm by joint conviction in the fight against impunity. Any act that may undermine the global movement towards greater accountability for atrocity crimes must be avoided. There are too many situations in the world where populations are experiencing or at risk of atrocities. What is required is greater dialogue and cooperation between us to all jointly strengthen the international criminal justice system. We, on our part, I can tell you, will continue to honorably meet our mandate undeterred with utmost professional integrity and in strict conformity with our mandate under the Rome Statute. For the sake of the victims of atrocity crimes, we must not lose progress made. We cannot allow humanity's call and the progress made towards greater accountability for atrocity crimes be undermined at the altar of political expediency and by grand, self-serving political designs. This struggle is a collective one, and the stakes are high. The system is being tested precisely because it is working. No one said that this line of work was going to be easy, but we must stay the course. Ladies and gentlemen, Your Excellencies, ending impunity is not the preserve of any single institution or person. My term as prosecutor is nearing its end in June, but our important work shall continue. Increased collaboration and shared practices between the court and UN accountability mechanisms is vital. Together, we must take coordinated steps to hold accountable those responsible for the most serious crimes and to prevent further atrocities. We cannot undo the suffering of the past or the horrors of history, but we have a joint responsibility not to repeat them. I thank you for your attention.
Thank you very much, Madam Bensouda, for so succinctly reminding us of the huge distance and the challenges as we go from the slogan of seeking accountability and justice towards the reality of a criminal prosecution and the use of evidence, and of course defending the rights of the defendants also properly. Of course, the ICC was always viewed as a court of last resort. It is ultimately the responsibility of states to carry out their obligations towards providing justice and accountability. Nevertheless, of course, I want to thank you for all of your tremendous work, perhaps a little bit prematurely as you're getting ready to depart. And also hope, as you have, that the new US administration will immediately reverse course and actually, we hope, begin working closely and supporting the ICC. And of course, finally, the issues that you raised about the need for collaboration and some of the challenges facing collaboration with various UN mechanisms, other independent or regional mechanisms, and civil society, which frequently is the first on the ground during that golden hour that you spoke of.
Yeah.
It's often victims groups and the civil society groups that they gather in who are the first to alert the world to atrocities and provide information. And this is, of course, exactly what the ICJ has been doing, and exactly what we will be speaking about in the next hour or so, and from our Global Accountability Initiative for the next few years. With that, I want to thank again all of our speakers, Foreign Minister Bloch, Assistant Secretary General Karas, Prosecutor Bensouda, for your time. Start moving toward our next panel with your agreement and approval, and to continue directly on some of the very important points that all of our speakers raised in the last session. To highlight the difficulties of actually being able to achieve international justice, I am reminded of a conversation that I had with a Rohingya activist in Myanmar a few years ago, who at that time asked me, what is the point of having NGOs and journalists gathering information about all of the atrocities that the Rohingya had suffered in the country. And my answer then was the same answer that I've given in multiple countries, situations of atrocities and gross human rights violations in Iraq, Afghanistan, Pakistan, Indonesia, Sri Lanka. The answer is always that we hope that this information will lead to a justice mechanism, whether in your own country one day or regionally or internationally, that finally will provide some accountability and some justice, a sense of truth of what has happened, and potentially reparations, and that together all of these will result in a guarantee of non-recurrence. Of course, that is the classic legal basis for the notion of accountability and the demand for the right to justice. To that Rohingya activists, I think today, I would say, look, all of those efforts have moved forward. There are no less than 4 different mechanisms at different levels that are addressing those atrocities in one way or another. And although we don't have results yet, it is nevertheless clear a move in that direction. And that is something that I hope he would be pleased with, and that I think the international community can seek some solace in. But as we heard, one of the major problems that we've seen is the lack of a consistent approach in responses to atrocity situations, and the very real role of geopolitics, especially of superpower politics in many cases, where especially the Security Council stands as the gatekeeper to the International Criminal Court. And of course, perhaps one of the starkest examples of the failure of the international community has been the situation in Yemen. What has been called by the United Nations as the gravest man-made humanitarian crisis right now, where for years thousands have been killed, injured due to war crimes, and have suffered significant malnutrition, starvation due to blockades. And yet the international community has not really been able to respond in the way that that we had hoped. So can we say that the system has really progressed when so many millions of victims around the world continue to be frustrated in their search for accountability, where impunity remains the order of the day in so many places around the world? As we finished the discussion in the last session, we got a sense of the dynamics that are facing us right now. There is a proliferation of new mechanisms. These mechanisms are increasingly moving toward what are normally considered accountability functions, gathering evidence up to a standard that could potentially be used in a criminal prosecution, which is a very high level of standard, far beyond the work that human rights investigators like myself used to do 15, 20 years ago. And in some cases, we have mechanisms that are gathering evidence, even though it is not quite clear which tribunal, which prosecutor will ultimately use that evidence, and when, and under what rules. Of course, the increasing reliance on universal jurisdiction in a few states around the world is again positive, but this also comes with some hints of politicization and raises difficulties of its own. These are some of the questions that we are now going to address in our upcoming panel. The panelists that we have today represent a wide range of experiences, from those who have worked directly for victims and who have worked directly with victims to document and monitor the situation, to those who have had a long-standing role in trying to provide concrete accountability and justice, especially in transitional settings. As part of the work of the International Commission of Jurists Accountability Initiative, we have been trying to bring together similar panels and to foster these discussions so that we can ensure that all of the processes, especially the ones that were highlighted by Prosecutor Bensouda, are moving forward in a way that can ultimately respond to the increasing demands placed on them, certainly by states that we now see in the Human Rights Council, in the General Assembly, and in other fora. So I will turn over to the panel now. And one of the questions that perhaps given the speakers themselves that I want to maybe have them focus on is that Yemen and Myanmar are examples of countries where we have seen appalling ongoing crimes under international law. And while we've seen some progress in Myanmar, we haven't seen the same in Yemen. What can be done to ensure that the world takes a more objective and a principled approach to justice for the victims in different countries, who after all have exactly the same human rights, regardless of what country they live in? And what are some of the options that we can consider to hope for a more coherent response when serious violations are being reported? How can we try to depoliticize the process and to ensure that evidence is gathered in that golden hour as soon as possible after atrocities are committed, and that evidence can lead to successful prosecution that will result in actual accountability for the perpetrators? I look forward to hearing the responses to this question and others from the members of the panel. I would like to ask all of the members of the audience, because we're running out of time, because we're always going to be short of time actually, if you have questions, it is best if you can write them beforehand and send them to me in the chat function, and I will try to make sure that all of the questions are answered by the end of the discussion. So let me begin by moving to our panel, if I may, and I will start with Radia Al-Mutawakkil, who is a Yemeni human rights defender. She's the chairperson and co-founder of the Muwatana Organization for Human Rights, and working since 2004 to address war crimes, arbitrary detentions, enforced disappearance, freedom of the press, and the full spectrum of rights violations that unfortunately are now manifested in Yemen. Radia Al-Mutawakkil has presented her work in numerous international events and forums at the European Parliament, the UN Security Council in 2017, and before the US Congress. And in 2019, she was on Time Magazine's list of 100 most influential people. And we hope that that influence will only grow and will result in concrete steps forward towards accountability. With that, if I can turn over to Radia Al-Mutawakkil for responding to my question and raising some of the other issues that she may have.
Thank you, Sam. Hi to everyone. I am glad to be with you. I'm glad that the discussions regarding accountability is still going on in many different levels, because I am from the country that is known as the worst humanitarian crisis, and I believe that has happened not only because of the war itself, but because also the huge lack of accountability. Even if there is a war, Yemen doesn't have to be the worst humanitarian crisis. It happened only because all parties to the conflict trust impunity more than anything else. We have been talking about UN mechanisms for accountability mechanisms, and I want to talk about two different things. First of all, because there are a lot of investigative mechanisms, whether in Yemen, in Syria, or in Myanmar. Even if these mechanisms started to collect and preserve evidence, even if they have started to build files, they are still investigative mechanisms, which is a very, very important step toward criminal justice or toward accountability. But I don't consider them accountability mechanisms because they don't have the mandate to hold anyone accountable. But as has been said, the information is the base of any accountability work in the future. And we as a civil society with other international NGOs worked a lot in the Human Rights Council in order to have an international independent investigation in Yemen. And it was very, very difficult battle because of many political reasons. But in spite of this, we succeed to have an investigative mechanism in Yemen. And this is because in the Human Rights Council, especially in the Human Rights Council, the challenge is it is consists of states, and some states, they are not friends of human rights or they have their own political approach. But the chances, it consists of many states, and there are still states who believe in human rights issues, and civil society can still play a role to push toward any resolution or decision in the Human Rights Council. And because in the Human Rights Council there is voting, but there is no veto. So from here, I will talk specifically about Yemen, because in Yemen, we as a human rights NGO documented a lot of information or documented a lot of violations, and we try to make it in a very high international level so it can be used one day for accountability. And also the investigation mechanism are doing this work, but there is no path toward any criminal justice mechanism. None of the very direct parties to the conflict in Yemen has signed the Rome Statutes, for example. It is most of the UN, we have to admit that most of the UN accountability mechanisms are controlled by the UN Security Council. So even the Human Rights Council, even if they are states, there is still a space to work and to push and to get a result. But with the UN Security Council, we cannot do this. So it's blocked. So one of the recommendations from the GEE, which is the group of eminent experts that is related to Yemen, was to refer the Yemen situation to the ICC. But we all know that UN Security Council will never do this for political reasons. And because we have this is thing that called veto. So from here, I think, and also the universal jurisdiction when it comes, we have a lot of Umar in Yemen, but they are all in Yemen. So when we started with our international experts to discuss the universal jurisdiction, the first question we have been asked as a local NGO, do you have a Yemeni diaspora in Europe? No, we don't have a Yemeni diaspora in Europe. So that made even the universal jurisdiction very complicated to be used in the Yemen case. So what are the paths of accountability? And when I talk about accountability, I mean criminal accountability. I want criminals to be held accountable. And I believe in documentation, but it is only one step. So I would suggest, even if you just think that such suggestions might sound crazy, but there is nothing more crazy than the violations and criminal and crimes that happened in any war. I think that the Human Rights Council and the General Assembly should have the power to refer situations to the ICC. This is something should not be only in the hands of the UN Security Council. If it was moved by any way, it's a long battle, but we should go through this path. The UN Security, the Human Rights Council, or General Assembly can have the power or the mandate to refer any state or any situation to the ICC. This will make huge difference in the accountability work in general. Also who has the power to design like a special court? Most of the paths that goes through also the UN Security Council. So there should be different mechanisms that have the same mandate that now the UN Security Council is having. Even in Myanmar, still most of the work that has been done, it is related to investigation, but no one will be held accountable if there is no accountability, criminal accountability mechanism to do this. This is in general, and I will leave the rest for questions. Thank you.
Thank you very much, Radia. You asked all of the very hard questions and some really strong answers. And I think the role of the Security Council in particular, as not as a gatekeeper, but as a blocker to international accountability, it certainly deserves further attention, and therefore the need for alternatives. Let me turn now to my colleague Cecile Aptel. She is the Chief of the Rule of Law and Democracy section in the Office of the High Commissioner for Human Rights, somebody who's quite closely involved with some of the mechanisms that we've already heard discussed already. And I'd like to turn over to Cecile to answer the same question and to offer her thoughts about what are some of the ways forward. Cecile, over to you. I'm not sure.
Can you hear me?
There we go, Cecile.
All right. Sorry. Thank you very much, Sam. And thank you very much to the government of the Netherlands and the ICJ for convening this extremely important but also timely discussion. Maybe just thinking of your question on this accountability mechanism and accountability more generally, I think it's important to remember that both the new mechanism but also the other accountability mechanism have been really growing usually very organically in a sort of an ad hoc fashion against a background of particular political or geopolitical considerations. So this has indeed led to situations of selectivity and disparity. The selectivity is on the fact that it's very clear that all of the situations under scrutiny by the various mechanisms, including this new mechanism, certainly entirely warrant the attention given to them. But there are indeed several other situations where the suffering of victims, the destructions of societies have also been very severe, but we have not necessarily seen the same reaction. So this poses the important challenge, leading us to have to reflect as to whether it makes sense for new mechanisms to be established one after the other, or whether there is the need for some form of a more standing mechanism which will ensure more coherence and systematicity. It's also important to even think not only in terms of impunity gap, but even the functioning of these different mechanisms would really benefit from, instead of having separate mechanisms with the risk of disparate approaches, different procedures or methodologies and standards, it may very much be in favor of those mechanisms to be more consolidated. It's clear that the colleagues at the helm of the different mechanisms, the new ones and older ones, have worked very hard to identify and maximize commonalities, including the shared use of platforms. But the question of whether different teams with unequal resources that are separately performing very similar investigative and cooperation function, is that the most efficient way of being organized? So beyond the political and geopolitical question pertaining to the risk of these vacuums sometimes, it seems to in any case be very timely to rethink that. I think that though, before we question what can be done, answering your second question, what can be done, I think it's important first to recognize what has been done. And while it's imperfect and while it's patchy, there are many important different mechanisms that have been established by different fora, including by the Human Rights Council, such as commissions of inquiry, of course, fact-finding missions, expert groups. In fact, like in Yemen, there is that expert group working on that situation. In addition to the other existing mechanism, the country independent experts, the thematic special procedures mandate, and of course, also very specific fact-finding missions that are being deployed directly by the High Commissioner for Human Rights in very different situations. So I think that all of this is seeking to really ensure that that we leave no place with really no attention. But it's clear that much more can be done. And I think that within OHCHR, we have been trying to also see how we can better consolidate the support being provided to different mechanisms. In fact, with support from the Netherlands, we have been really consolidating the support to fact-finding, commission of inquiry in the delivery of their respective mandates, but consolidating this. And of particular interest are also certain projects ongoing, like one for the Democratic Republic of the Republic of Korea, this DPRK accountability project that seek to really take a new approach, novel approach toward taking forward findings of a commission of inquiry that worked in 2014 in a situation where there seemed to be very little perspective for progress on judicial accountability in the foreseeable future. So I think we've tried to already be very innovative with, for instance, on DPRK, a team in Seoul, a team in Geneva with expertise in international criminal law, really trying to collect information and evidence, but also establish a central information and evidence repository and develop strategies for future accountability processes. If you want me to answer what I think can be done, in addition, I think certainly funding is a key issue. And the efforts of any mandate. So some of the new generation, some of the older generation that I was mentioning, they're all, in fact, made more difficult by the lack of predictable and sustainable funding, which make their work much more complicated and at times even sometimes, dare I say, unrealistic, you know, the mandate vis-a-vis the resources when they're not matching. So that those that are at the head of these mechanisms are required sometimes to spend a lot of time seeking to identify resources may not it may distract their attention, take it away from the core mandate, which is accountability. So identifying more sustainable funding will be a very important step forward. A second recommendation I would have is better tools and digitalization. In today's world, in 2021, we have to adjust the tools, have state-of-the-art tools, notably to identify, access, review, analyze key information and evidence, including digital and forensic. I will just quickly, briefly mention two other last, ideas that I would like to put. One is the linkage with other processes, and we've been mentioning transitional justice, working better together for those different mechanisms, ensuring complementarity of mandate, linking up with truth and other forms of transitional justice, truth-seeking mechanism. I think that linking to that broader transitional justice processes and initiatives will best contribute toward especially the key issues of placing the victims at the center of this mechanism and really addressing their horrendous violations or abuse that they have suffered. But my last point will really to come back to the question of selectivity that I started with, so addressing that. Thank you.
Thank you very much, Cecilia Patel, for identifying both the political questions and then some of the real issues, such as funding, such as access to technology that are important. Let me call on Professor Andrew Clapham, who has some insight, of course, into how these accountability and documentation mechanisms operate from the inside. Professor Clapham is at the Graduate Institute of International and Development Studies in Geneva. He is a former commissioner and honorary member of the ICJ, I'm pleased to say. And since 2017, he's been a member of the UN Commission on Human Rights in South Sudan. So also a very interesting new mechanism, and one that is different from some of the other ones that we have seen. So if I may turn over the floor to Professor Clapham for 5 minutes.
Okay, thank you very much, Sam, and thank you for that introduction. as you say, the South Sudan mechanism is what was called the new generation of mechanisms. It's a relatively new approach. And maybe I'll just outline the 3 levels of accountability that we're working on. So at the first level, we're looking to gather and preserve evidence for the purposes of crimes at the national level. Those could be under the ordinary criminal law of South Sudan, under military justice, or under some of the laws which incorporate the Geneva Conventions. At a second level, we have been mandated by the UN Human Rights Council to collect information for use in a future hybrid court for South Sudan, which is to be established by the African Union, together with the government of South Sudan. Now, we're still waiting for that court to be established, but we are preparing dossiers that a future prosecutor could, as soon as possible, start those investigations. We don't have the problem that the prosecutor of the International Criminal Court, Ms. Bensouda, referred to, because our hybrid court does not yet exist. And at a third level, and perhaps this is the most interesting for this group, we prepare dossiers, we collect evidence for use in what's been referred to as universal jurisdiction cases. And perhaps in contrast to the Yemen situation, which we heard about, some of the persons of interest from South Sudan do travel abroad, and there would be the possibility to prosecute them. Now, we don't stick only to the core crimes, the sorts of crimes that would be prosecuted at the ICC. In fact, we often reformulate the same facts and, if you like, put them into the box of torture. Why do we do that? Because there are 160 states parties to the Torture Convention. And I suppose paradoxically, it is more likely that a state will have the possibility to prosecute torture at the national level for somebody who committed their crime abroad than for crime against humanity or a war crime. We also prepare dossiers with regards to enforced disappearance, because again, there is jurisdiction in the state's parties. I was very interested by what the prosecutor said with regards to how the new generation has now learnt to deal with information in order to prepare it for a possible criminal prosecution. Indeed, we are very careful about questions of chain of custody and the way in which witness statements are collected so that they can be used in a court of law. We are lucky in that we have a number of former employees of the International Criminal Court or the Rwanda or Yugoslavia tribunals who are very much aware of the sorts of faults that one could find in the information that a defense counsel would be able to point to in a court of law. So I think there's been huge progress on that front. If you ask me to talk about the challenges going forward and what should change, I would say one of the biggest problems we have is witness protection. That's obviously a problem across all of these mechanisms, but you can imagine that it's all very well collecting evidence and talking to people. But if those people are then subsequently put in danger, we're doing more harm than good. A second point, which is alluded to by Cecile Aptel, is the digitalization of equipment, but also access to the archives after a commission like ours or a commission of inquiry has disbanded. That is something that we're very much aware of, and we've tried to set out protocols as to who would be able to have access and under what conditions, always again primarily being interested in the security of those people who have cooperated with us. And lastly, if you're asking for a wish list, I would say yes to resources, but the primary problem I have noticed is with regards to the job security of staff. The staff are in an incredibly precarious situation, obviously operating in more or less a war zone for much of the time. And then their contracts will only run up to the end of when the mandate of the commission is going to be renewed, and they're often poached or they need to move on to other jobs. And there isn't a pool of experts who can keep these jobs continuously running so that evidence is not lost between events. We do have what's now been referred to as this golden hour. We have about 13 people on the ground in South Sudan, but the job insecurity of the staff, I would say, is the primary obstacle to us doing our job, apart from, of course, all the geographical questions on the ground and the political questions. Lastly, in closing, I'll just say that in interviewing the victims of war, as Sam suggested, now for several years in South Sudan, I've been surprised over and over that, of course, their requests to the UN are for food and water and internet access and all the things that you would expect. But there is also a thirst for justice. And every time I have interviewed a group of internally displaced or refugees or victims, they have always said that they want justice, not necessarily justice for their crime or for all the crimes that have been committed, but justice and accountability against some of the leaders some of the time, and that would be a huge start. So thank you for having me on this panel.
Thank you very much, Andrew Clapham, raising a mix of issues from the high-level geopolitics to the structure of an accountability mechanism, and then to the very prosaic realities that we have to deal with. Let me turn over to the fourth member of the panel, Dr. Ambia Parveen, who is the chairperson of the European Rohingya Council, co-founder of the Rohingya Medics Association. Dr. Parveen is currently working in Germany as a pediatrician and a psychiatrist for children, and I asked her to also provide views on especially the situation with the Rohingya, which was for a time particularly high profile. For a few months, it seemed that media from all over the world had descended on refugee camps in Bangladesh. And we now have multiple mechanisms who are trying to respond to the same atrocities in different ways. And we've already heard from Prosecutor Bensouda that there is certainly a need to ensure that those processes are all working in a way that supports one another rather than getting into each other's ways, because ultimately there are still tens of thousands of Rohingya who are awaiting justice, and meanwhile, immediately their needs within the refugee camps in Bangladesh and for those who are within Myanmar remains largely unmet. Dr. Parveen, over to you for 5 minutes.
Thank you, Sam. Your Excellencies, Kingdom of Netherlands, Minister Stef Blok, Friends of Rohingyas and Humanity, thank you for having me here, and good day and good evening wherever you all are. There are so many bodies and so much of blood in the river. It looked like that the river was bleeding, said by an 18-year-old Rohingya female from Butidong. In Myanmar, still till today, the judiciary system is badly influenced by the government and by the military. According to the 2008 Constitution of Myanmar, the army chief has the final words, and no laws, no courts can go against his decision. Like in Indar massacre happened in Arakan, where military or soldiers were punished for 10 years for killing brutally the Rohingyas. They were supposed to serve 10 years in the jail, but they could leave the jails without fulfilling the imprisonment because the army chief has the right to give full amnesty to those soldiers. The willingness of bringing ex-officials to justice in Myanmar, almost none, especially for the crimes committed against Rohingya. Accountability is still very far as the government consistently denying the crimes. So the acknowledgement is not present. For accountability, first step is acknowledgement that the crimes have happened. It has been committed, from whom and where. Now in Myanmar, the spot is strongly covered up by the government. so the criminals are automatically offered impunity. Today, of course, more and more institutions need to adopt creative ways to deal with countries that seek to accept the jurisdiction of international criminal law of mechanisms. For example, in Myanmar, it's not a signatory to the Rome Statute, and thus ICC does not have jurisdiction, but the court sought jurisdiction over the matter by looking at the place where the refugees have been forced to flee, which is Bangladesh. There is a state party, and hence court established jurisdiction. Similarly, work of an independent body like IIMM remain important, as Myanmar government's own report on the atrocities inadequate. Myanmar government's report admits to war crimes, but Myanmar does not reveal full report. Thus, we do see that there is international will to make a change. However, the process still remains inadequate as the victim voices often get lost. Investigate bodies must be careful of the following: risk of re-traumatization by frequent questioning and answering, which can reinduce their trauma. Over-sexualizing of the woman by focusing too much on sexual crimes risk them to live with the stigma forever. While gender nature of the genocide is important, can cause one to ignore the plight of men, children, LGBTQA, and disabled, etc. Justice often comes too late and too little. Sometimes investigative mechanism work, such as the work of the fact-finding mission in Myanmar, in such that in many amount are tampering with the victims' testimonies, and this may hinder the work of the court level. In court, the following points must be kept in mind if possible. Focusing too much on the technicalities, differences between genocide and crimes against humanity, so much that the voices of the victims oftentimes become secondary. There is a little space for victims to put forward their views in the ICJ, especially which presents the case as a fight between two states with minimal direct victim participation. We don't want a lot of victims to be made witnesses, give testimonies, but their voices should be heard. IIMM is the better in that respect. Enforcement mechanisms of international court is weak. Even if it is adjudged that there is a genocide, how will the victims really get justice if the court cannot enforce the decision? Advice for the future. Even as the past is being recounted to ascertain accountability, the present and the future of the victims should not be forgotten. Like these days, many Rohingyas who are chronically traumatized and also due to the daily stress factors are being transferred to Bhasan Char Island forcefully. To re-traumatize the victims, proper training of investigators and proper mental health and psychosocial support. Even as women remain central to the massive amount of sexual and gender-based violence, the agony and pain of the victims, including men, women, disabled, LGBTQ, elderly, must be recognized. A proper repatriation mechanism must be constituted, the reins of which must remain in the hands of Rohingya organizations themselves, not only on foreign bodies and NGOs, that they are not fully aware of the pain of the people. I end. International justice system should have the power to impose sanction, punishment, etc. independently. In clear terms, there should not be any veto power countries, but international justice system should be completely independent. I thank you all once again.
Dr. Praveen, thank you very much for reminding us about the ongoing horrific situation facing the Rohingya, and also, of course, again, the need to address the central role of the victims and survivors. After all of these efforts are really simply to respond to the individual rights of every single person whose rights have been violated, and I hope we'll be able to respond to that. I'm going to open the floor now and call on some questions. I've received quite a number of questions. I'm not sure that I will get to every one of them, but I will try to put them together. But I think just to segue precisely from what Dr. Praveen said, I'd like to call on Omar Al-Shogre, whom we heard about earlier today from Minister Block, to talk about his efforts, what he, of course, suffered directly as a victim and as a survivor, and now his efforts to seek accountability for the atrocities that he suffered and others in Syria have suffered. Omar, if I could ask you to make a brief response, maybe to some of the same questions that we've heard, and I can, if I can, give you 2 or 3 minutes, Omar. Thank you very much.
Thank you. Ladies and gentlemen, years of war have killed civilians, it has killed children, but it has also created heroes. From early days of demonstrations, being in the front side, facing the regime soldiers, the regime guns, or holding a camera to document, or just whispering the word of freedom. Far away from the fancy speeches, today I unfortunately see the lack of support to small organizations and individuals who sacrifice or put unlimited time to save, protect, or sort the evidence available against the criminals and war criminals. If I record a video in my phone in a demonstration where the regime kills 10 people or so, most of the time the video will stay in my bucket, in my phone, because of the lack of trust to global organizations who actually failed to save my country, my people, in many different ways. Because of their bureaucratic system or misled leadership and other reasons, I believe global organizations need to regain trust through the support of the small and few trusted individuals. Period. Striving to accountability puts a lot of survivors in risk. The guard who tortured me have called me to threaten me and say, "I want to kill you or you shut up." And they can reach out. The war is not over. The regime is still targeting heroes. The regime is still killing people. I think supporting the families of victims and witnesses who survived, everyone who is connected to the legal prosecutions, it's a moral act we should do. Too many heroes are being killed every day by brutal regimes, not only in Syria, but in many countries. And we actually knew from the first time we went out to demonstration that the regime will kill us. The regime going to kill people, but we had hope. We had hope that the international community and every single democratic country would not leave us alone fighting the dictatorship. But more than that, we had hope in the good individuals like you in this panel. A lot of people now are losing hope, and now our priority should be to give hope again, to regain trust. We expect, as Syrians, we expect the good people inside of you, not only you as politician or human rights activist or what you are. It's like the good person inside of you, we expect him or to act, to react. I have a video of my father being killed. I found it on YouTube. And guess how many people have found videos, not only of their families being killed or tortured in prison, but of the guard enjoying these moments. It's a moral act that we should not let that just go because people lose trust. I decided to go the way that I trust organizations. I work with the Syrian Emergency Task Force. I go to the Congress, the European Parliament, because I believe somewhere I will find this right person who will care about this cause and will fight day and night to help us achieve justice and bring freedom to my people. And that person may be one of you. I expect the best of you. Thank you.
Omar, thank you very much for reminding us of the reality of the situation, and to say that, of course, our task is to provide you and your family access to justice, and ultimately, I hope, accountability for all that has happened, so that others who are trying to exercise their rights freely don't suffer the same fate that you have. As you said, you knew that there were going to be repercussions, but you trusted the international community when it said that everybody has individual rights, and when those rights have been violated, that the perpetrators can't rest assured in the impunity that they have so far enjoyed. And I think I can only say that we can only salute you and support you in your ongoing efforts. And well, I hope moving forward there will be more advances. Thank you very much for what you've done. Let me open the floor now to further comments and questions. The first in line is Ambassador Peter Matt of Liechtenstein, another state that has been quite dedicated to supporting international accountability. Mr. Ambassador, over to you. If I can request for 1 or 2 minutes of your time. Thank you.
Thank you very much, Sam. I would like to start with thanking the Netherlands and the International Commission of Jurists for organizing another interesting, very insightful event following the accountability conference that you held in autumn last year. It showcased the complexity of accountability and the importance also to further discuss this issue, the importance of keeping it on this topic on the agenda, and the timeliness of the conference. We very much appreciate the efforts of the Netherlands at the Human Rights Council and beyond to bring accountability forward. This goes in particular to the strong support to the ICC, a priority we very much share with the Netherlands. And we are also happy to be co-chairs together with the Netherlands on the accountability group in Geneva that has been launched 1 year ago, or in autumn last year, 1 ago. I think the statements of the distinguished speakers this afternoon again showed the importance of the topic. And I would also, like you did, Sam, very much commend Omar for his statement, for his courage to come forward with his heartbreaking story. I think it's important to hear testimonies to bring forward the issue of accountability. It of course also shed light on the frustration we all share when we address this issue at the international level. Just to mention the lack of trust among states, as well the fundamental differences with regard to how address the shortcomings in implementing core human rights obligations. Very briefly, I mean, Liechtenstein has been spearheading alongside with Qatar and many like-minded countries the international impartial independent mechanism on Syria. And in a situation where the country concerned is not willing to cooperate, such a mechanism can be the last resort to ensure that evidence for serious violations of human rights and humanitarian law is collected, and then impunity in the long term hopefully will not prevail. The creation of the triple IM, and this is something some panelists also mentioned, was also due to the blockade in the Security Council, which is not living up to its responsibility. And it's also a way of kind of reinvigorating the role of the General Assembly. And I would also, of course, like to mention the important role the Human Rights Council has played in creating the mechanism on Syria. At the same time, I think we may not forget that ensuring accountability and bringing human rights violators to justice is the primary responsibility of states. I think also some panelists have mentioned that. And there, I would just like to, that would also, my question would go in this direction. I mean, trust in accountability mechanism often remains a challenge. And how can we deal, how is this dealt with, and how can we trust or improve, can the trust be improved so that the work of accountability mechanisms can be enhanced through the cooperation of concerned states? I think we may not forget that as important as the role of the UN, all the UN mechanisms are, we also have to work on the national level. And with this, again, thank you for the co-conveners and the excellent panelists for a really very interesting discussion. Thank you.
Thank you very much, Mr. Ambassador. And again, we appreciate Liechtenstein's hard work in this regard. As we're running short on time, if I may, I will try to consolidate some of the questions that we have received both here and I think on the hundreds of people who are watching on the live stream. And we have one set of questions regarding the responsibility of various states and the politicization that we've already talked about. The Deputy Permanent Representative of Armenia to the Council has asked the question about sovereignty and how do we respond to those states which claim that their sovereignty trumps any international investigation of potential violations that have happened. We received a question also from Iran regarding politicization. How do we decide which countries are selected for scrutiny, which come under investigation for accountability, and additionally, moving on to colleagues from Amnesty International who pointed out that there are now efforts to try to strengthen universal jurisdiction cases. And of course, universal jurisdiction cases address both issues of sovereignty when one state stands in a judgment of events in another state, and also questions of politicization. Many of the major arms sellers, for instance, around the world who are involved in some of the violations we've addressed reside in the West and potentially need to be questioned for their role in perpetrating serious violations. So if I can actually, for those two questions, turn to Professor Clapham and Cecile Eptel to give some brief responses on how they have dealt with this issue of politicization and questions around sovereignty and universal jurisdiction. Cecile, if I can start with you, maybe.
I thought you would start with Professor Clapham.
Well, Professor Clapham seems ready, so okay, I'll turn over to him.
Okay, thank you. Well, given the time, I don't want to give a long lecture on sovereignty, but my short answer would be that when a state joins the United Nations or joins the Convention Against Torture, they accept what that treaty says are their obligations, and they accept that their nationals can be prosecuted in other countries because that's what the treaty says. And when you join the United Nations or the African Union, you pledge to cooperate. And if the UN asks for a fact-finding mission, that's part of being a member of the United Nations. So I don't think there's a tension with sovereignty at all. And on the universal jurisdiction question, I mean, I don't think we're really in a situation where we have to worry about selectivity and politicization. We just want some cases to be prosecuted under the Torture Convention or under universal jurisdiction. At the moment, there are hardly any. And compared to the atrocities and the crimes and the tortures and the killings, as we've heard from Omar and others, all we're asking for is a few cases. I don't think there's a problem of politicization at all.
And I knew that having Professor Clapham go first would really sort out most of the issues. I'd just add that, in fact, if we look at the various layers where criminal accountability can be pursued, it starts indeed at the national level. This is really where states have all of the laws in place, usually to be able to prosecute, investigate, and prosecute crimes that are committed on their territory or by their nationals. But so that's a systematic part in fact, part and parcel of sovereignty. One of the core attributes of sovereignty is the capacity of states to deliver justice. And from a human rights legal viewpoint, we really consider that states have an obligation to really investigate and then further accountability when some of those violations or crimes have been committed or abuses by non-state armed groups. It's only if there is a failure at that level to really pursue accountability and ensure that there is redress for the rights of victims, that then other layers are activated. That is only if there is such a failure and such an impunity gap that then organizations like the Human Rights Council will be then considering whether or not to establish a specific mandate, whether a fact-finding, a commission of inquiry, whether then the General Assembly may consider establishing an international mechanism or the Security Council seizing the International Criminal Court. But it always starts if there is a vacuum of accountability and criminal investigations and prosecutions having started at the national level. And then if we really look at the question of the question that was asked, who decides then on when there is a mandate? Those decisions are made by states in those different, before those different entities, whether that's the Human Rights Council or the General Assembly or even the Security Council.
Thank you very much for that, Cecile. Let me then ask you another set of questions that I've received regarding issues around how we can how international mechanisms can best support victims and civil society organizations. How do we deal with issues that we heard mentioned around the protection of victims, around harmonization of evidence, particularly when we know that there are multiple mechanisms that are looking at the same events, especially when they're addressing quite culturally sensitive issues such as sexual and gender-based violence or violence against people on the basis of their sexual orientation and gender identity. If I can ask Dr. Perveen and Radia to give some quick responses from what they've seen on that basis, that would be wonderful. Dr. Perveen, maybe you can go first.
Thank you, Sam. We have been working, with the Rohingyas, and they have been, like in 2017, when there was a mass flee of Rohingyas due to the last phase of genocide happened. There were many NGOs and politicians and the international mechanism investigators were there while doing the interviews and testimonies. I think, sorry to say that the majority, some of them were not aware with our culture and the religious issues, and also due to the lack of the language, they have used like males, even Rohingyas or the Bengali citizens, and they have did the interviews and the testimonies with the women, where our women are very, very shy, are very reluctant to open up. And in those cases, they were not a very authentic interviews were there, and then there was a language barrier. So it is very much important in general. What I want to say is that it's very much important that the Rohingyas himself should be involved instead of only the foreign speakers or the one who are aware of many investigations and many mechanisms. They are very aware of lawful things and all that, but still it's very much important that these testimonies are held with the Rohingya people, with there should be a language, there should be a proper social, psychosocial support, and not leaving them alone. So that is the best thing, and to involve the locals, the victims, the survivors. Thank you. And by not doing frequent interviews, because it will re-traumatize them again and again. These are the Rohingyas who are vulnerable. Even if they have left the country, they might be not be, they might be away from the fear of Myanmar government or Myanmar army, but in the camp still the people are going with daily stress factors, and due to the repatriation, coming, going, now relocation, they have been constantly traumatized. So I will request our people, the people who are engaged with certain things, that to make sure that they are not re-traumatized, their traumatized factors are not induced on and off, and also at the end of the day try to give them proper psychosocial support, and especially the trauma therapy, because in the camp people are not getting any trauma therapy, which is a luxury, and not everyone is aware of certain counseling. Thank you.
Thank you, Dr. Praveen. Radia Al-Mutawakkil, can I get your views on this?
Yes, regarding how can investigative mechanisms support civil society, I guess just by doing their work. We are, for example, a local NGO who exists all over Yemen. We have field researchers all over Yemen who are documenting violations all the time, and we can support the investigative mechanism like the GEE. But there is one option that we will stop if the civic space continued shrinking. This is what happened in every war zones. The space of civil society is shrinking. So if I'm not in the ground, if I cannot work anymore, then this is a disaster for me. If I'm still there, still have the space to work, to document, to advocate, to search for avenues for accountability, this is what all I need, to push parties to the conflict, to keep at least the civic space there, and not to shut down all NGOs and all individuals who are trying to work in civil society. There was a question about the weapons. Because we feel in Muwatana like we are digging the wall, trying to find any avenues for accountability, international criminal accountability, because locally there is no state and we are controlled by armed groups. So some of the possible avenues was like the arms trade, because those states who are selling weapons to Saudis and Emiratis, like the US, UK, Italy, they have laws and principles, and through their court, we still can, prosecute them. Or, for example, we filed a complaint in Italy regarding one of the incidents where the whole family was killed, and we couldn't find remnants of weapons, and there was an Italian weapons. And also we have submitted a communication with our international partners like the ECCHR and others to the ICC. So the only avenue that we could use available international mechanisms for accountability was through weapons and arms trade. So it's good, but we don't want this to be the only avenue that we can do. And still even didn't get that clear result. So I will just emphasize again that it is very, very limited. Accountability mechanisms, which is criminal justice, accountability is very, very limited, and there should be a solution for this, above to all the great investigative mechanisms that are happening everywhere.
Radia, thank you very much for that. And of course, you really pointed out that one problem with universal jurisdiction is not necessarily politicization or selectivity in any way other than just simply the luck of having a defendant being available in one jurisdiction or another. Everyone, we are running slightly over time. I have asked for an extra 5 minutes, if I can, for So please bear with us. I promise that we will finish everything by 15 minutes after the hour, but the conversation is going in a very important direction. I want to also ask, give the floor very quickly, if I can, to Stephen Rapp, former U.S. Ambassador for War Crimes Investigations and a veteran of some of these. Ambassador Rapp, over to you for 1 or 2 minutes, please.
Okay, well, thank you very much, Sam. Hello from Washington, where in exactly, let's see, 57 minutes, we'll have a new administration. And I will say from contacts with key individuals that I am confident that within the next week, we will see the revocation of this outrageous executive order that authorized the sanctions against Fatou and Fakizo. And we will see the United States again being a partner with our colleagues like the Dutch, with the governments across the world and the civil society in furthering accountability and supporting as appropriate the International Criminal Court because the world needs an international court of last resort, even though our primary recourse needs to be at the national or regional level. I would like to pose a question, and maybe there's no time to answer it, but it's a question I think for all of us to reflect on, and it arises out of the work that I've been engaged in with a lot of you that's been led out of the Oxford Program on International Peace and Security, where we have surveyed 160 individuals involved in this whole landscape, from the civil society organizations, including Mutwana, which we did survey, to the people that work within these mandates of various sorts, from the mechanisms which really focus on criminal accountability, to the fact-finding missions and the special procedures, but then finally focusing as well on 23 prosecution authorities. And if we're going to end impunity for these crimes, we have to be in this process delivering information and evidence that will work in a judicial process. And so I think the question I think all of us should be asking and responding to, particularly the panel, is what is needed at the international level, and what can states do to strengthen the expertise and the tools and the skills at each stage of this process to make sure, particularly in that golden hour, but then using tools like digital and open source media and other forms of documentation, that material can be delivered that is credible and verifiable to judicial processes, and that we have that kind of support for those efforts in this system. We may have it in the mechanisms for Syria and Myanmar, but of course we've got other mechanisms that don't have those resources. And what can willing states and the multilateral bodies be doing to provide that to the mandate holders, and also be strengthening it at the original sources, the civil society organizations that are present at the scene of the crime.
Thank you very much, Ambassador Rapp. We really have just maybe 30 seconds to give to the panelists. If I can ask, in light of everything that you've said, what would be your kind of one suggestion for a step forward to this conversation before we end this? Just give us kind of your top line request or recommendation, and I'll start with in reverse order with Dr. Perveen.
Thank you for a very wonderful question, which is not every time asked. And since you have asked, and since we are going to answer you, and I hope all of you will take us our pain seriously. Try to wear our shoes. We don't wish you to wear our shoes, but take us seriously. And especially, it's not about the Myanmar, it's not about the Rohingya. The world, instead of in this 21st century, we are so civilized, majority of us educated, we have luxury lives, but why still the world is going down? And I think that, like one of our brother Umar said, we need to see that it's not only a job, it is out of passion. And let us come together and do the commitment. And with the Gambia, with the ICJ, with the Rohingya case, Canada has supported them and they are supporting. Kingdom of Netherlands is supporting. USA, one of the democratic country of the world, why they are not talking about this genocide, why they are so just only the lip service, why we are still interested in the economical and the political things. It's a matter of human being. Let us all together, today maybe we are the victim of genocide, and this might come to you if we don't stop right now. Thank you.
Thank you very much, Dr. Perveen. Professor Klappa?
Thank you very much. Just building on what Stephen Rapp said and Omar said, I think we need to focus on a few individuals who have the power to change things. And I think we've spent a lot of time coordinating international prosecutors and international mechanisms, but it's probably the time to start to think about a network of national prosecutors who feel a sense of urgency about this and who could have an esprit de corps and collectively start to work to track where people are moving and come up with the innovation and the determination to hold individuals accountable. Thank you.
Thank you very much. Cecile Aptel?
Sure, thank you very much. And it is all about determination, as really said by the two previous speakers. So I'd like to really just end on underlining our joint responsibility, wherever we are, in whichever position, working for states, NGOs, the UN or other, our joint responsibility to ensure that all the victims of gross human rights violations and abuses and international crimes have access to accountability, that their rights are acknowledged, because ultimately it's also about their dignity being restored in all situations.
And Radia Madwakil?
Yeah, thank you. I just want to say that when I mentioned weapons, I mentioned European countries because I was talking about universal destruction, but we have also the US weapons, and we are still trying to file a complaint in the US. We couldn't find an avenue to do that. Anyway, whenever there is talk about the national accountability, I feel like a little bit sensitive because the war in Yemen is not only, Yemeni war, it's also regional, it's proxy war where Iran and Saudis and Emiratis are involved, and those who are selling weapons are also involved. So whenever I talk about accountability, it means to me only international accountability because it has the mandate to hold all these parties to the conflict accountable, and not only the Yemenis. I will just, at the last, pressure on the idea of asking to give, I don't know who should give, to give the Human Rights Council at the General Assembly the power to refer situations to the ICC and to form special courts, and not to give all the accountability keys inside the UN Security Council.
Thank you very much, panelists and members of the audience. On behalf of the International Commission of Jurists, I want to thank you all. Just recently, we celebrated the birthday of Martin Luther King in the United States. And of course, a famous quote attributed to him is that the arc of justice, the arc of history bends towards justice. I think in our experience, that's not really necessarily true. Or if it does bend, it certainly requires the strenuous efforts of good-minded people. And from our side, we've heard some of those requests. We need to work on this at the highest levels of international geopolitics and the Security Council, to issues of resources for international mechanisms, for and most crucially for civil society in the countries where the victims and survivors are seeking justice. And for the International Commission of Jurists and the global community of jurists that we represent, that is our commitment to seeking that. And of course, we can only do that with the support of people like those from the Kingdom of the Netherlands. So I want to thank you for your help in supporting all of us in allowing this meeting to come together. And with that, thank you, Ambassador Vandala. Over to you And thank you from the ICJ.
Thank you very much, Sam. We've come to the end of the conference, and I just want to thank all of you for your active participation. Also, all the people that have asked questions, but especially, of course, Raja Almadou-Wakkel, Cecile Abdel, Andrew Clapham, and Ambia Parveen for their very valuable contributions. The different perspectives that you have outlined show us the importance of documentation, evidence gathering by various mechanisms, contributing to accountability. As the Chief Prosecutor of the ICC has made clear, increased collaboration between the ICC and the UN, but perhaps also between all stakeholders is vital. We must take coordinated steps to address impunity and hold perpetrators accountable, of course. But what all speakers have emphasized is that victims need to be continuously at the center of our efforts, feel their pain, as Dr. Parveen just said. I think the tragic and yet inspiring story of Omar al-Shokri made us aware of the amount of work that we still have to do. We should all share the perseverance and the determination of Omar to bring offenders to justice. And as the organizers of the event, we will, together with the ICJ, follow up on the conference today and the previous one by reviewing the points that you have brought up. And the last round was very interesting in that sense, because there were very concrete suggestions made. And we'll do this with a view of further strengthening our efforts to achieve accountability in the end. I've mentioned it before, also in the last conference, the fight against impunity is tough, and it's a long-term effort, which is also part of the wider agenda of conflict prevention. Well, you can count on the Netherlands for it and its commitment to the international rule of law. And with that, I would like to thank you all very much for joining us this afternoon, and there will be more to come, I'm sure. Thank you.